What does the employer have to prove to get a temporary injunction in a Texas non-compete lawsuit? I'm Zach Wolf. I'm a Texas trial lawyer, and that's the question I'm going to answer today. If you've watched episode 6 of my videos, you already know that one of the most important events in a non-compete lawsuit is when the judge decides whether to grant a temporary injunction which enforces the non-compete while the lawsuit is pending. The wording of the requirements for a temporary injunction is going to vary depending on whether you're in state court or federal court, but the basic concepts are the same. So I've boiled it down to 5 key things that the plaintiff employer has to prove to get the temporary injunction. Let's talk about those. Marker, please. Thank you. So the first thing is probable right to relief. Sometimes this is referred to as likelihood of success on the merits. This just means that you have to persuade the judge that the plaintiff is likely to prevail on the non-compete claim at trial. The second requirement is imminent harm. Now, imminent harm is sometimes confused with irreparable harm, but imminent just means that the harm is either happening right now or is just about to happen. The third requirement is irreparable harm or irreparable injury. Irreparable means that it's harm that is not likely to be adequately compensated by a judgment for damages. So sometimes this requirement is also called no adequate remedy at law. The fourth requirement for a temporary injunction is that the employer needs to show that the balance of harm favors enforcement of the non-compete. This means balancing the harm to the employee versus the harm to the employer. The fifth requirement is that the employer needs to show that enforcing the non-compete through a temporary injunction will not disserve the public interest. So those are the requirements for a temporary injunction, at least on paper. But in practical terms, how do these really get applied in non-compete litigation? Well, this is just my opinion, but it's based on my experience litigating these cases as well as just reading a lot of non-compete cases. And my opinion is that the first requirement is by far the most important. The probable right to relief means showing the judge you've got a strong case for enforcing the non-compete. Now that comes down to 2 things typically. One is showing the judge that the non-compete is enforceable under Texas law. If you want to see an explanation of that issue, you can check out episode 1 of these videos. And then the second thing that comes into play with probable right to relief is sort of a moral element where the judge looks at how egregious is the conduct of the employee who is violating the non-compete. Was the employee really sneaky and underhanded, or was the employee acting more in good faith? That a lot of times can have a big practical effect on whether the judge is likely to grant the temporary injunction or not. Now the second requirement, imminent harm, in a non-compete lawsuit, what that typically comes down to is showing that the employee has already left the first employer, gone to another business, and started to compete with the first employer. If you show that, that's typically going to be enough to show that there is imminent harm. The third requirement is probably the trickiest one, irreparable injury. It's tricky because it's a requirement on paper, but judges don't always really enforce it. Sometimes judges apply this requirement so loosely that it might as well not be a requirement. What really happens, in my view, in a typical non-compete case is that the judge focuses on the first requirement. How strong is the case for enforcing the non-compete? If the judge thinks that the case is strong for enforcement, then as a practical matter, the judge is going to kind of give the plaintiff a pass on the irreparable injury. And one way the judge can do that is to say that irreparable injury is presumed when someone is violating a non-compete. That's kind of a way of saying, well, even if the evidence doesn't show it, I'm just going to assume that it's the case based on the nature of the violation. Okay, and I'll let you in on kind of a little secret, which is that in most non-compete cases, there really isn't irreparable injury. And that's because in most non-compete cases, you can do a lost profits calculation, which would be adequate to compensate the plaintiff through damages. That's in most cases, not all. So what really happens is that you have kind of a sliding scale where if the plaintiff has a strong case on probable right to relief, then the judge is going to be looser about irreparable injury. Conversely, if the plaintiff's case is kind of iffy, kind of borderline on the merits, then the judge is probably going to be more strict about applying the irreparable injury requirement. Okay, then finally you have these last two requirements, balance of harm and public interest. These are less important because these usually are just going to follow from whatever the judge decides on the first three requirements. If the judge finds a probable right to relief, imminent harm, and irreparable injury, then you can pretty much guarantee that the judge is going to say the balance of harm favors an injunction and that enforcing a reasonable non-compete is in the public interest. So there you have it, the requirements for getting a temporary injunction in a non-compete case. If you want to read more about irreparable injury and temporary injunctions and all of these issues, you can find some articles about this at my blog, 5 Minute Law. So I highly recommend you check out the blog, and thanks for watching.